Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology transactions and keep you up to date on the latest trends in data, digital, outsourcing, and software by drawing on the perspectives of practitioners who have executed technology transactions around the world. You can subscribe to this series on all major podcasting platforms. We hope you enjoy the program.
Hello, listeners. Today's topic is disputes arising from technology agreements. Companies are increasingly relying on third parties to provide critical services and technology to support their business objectives, and that means relying on their agreements with those third parties. The last thing anyone wants is for those agreements to become the focus of a dispute, but it happens. And our questions today are, why does it happen, and how do you minimize the risk that it will happen? My name is Julian Dibbell, and I'm your host. I am a senior associate in Mayor Brown's Chicago office with a practice focusing on technology transactions. Our guests today are my colleagues, Jim Ferguson and Sarah Reynolds. Jim is a partner in our Chicago office. He's a litigator whose practice focuses on complex commercial litigation and U.S. and international arbitration, particularly in matters involving intellectual property or information technology disputes. Sarah is a partner in Mayor Brown's International Arbitration Group. She's based in our Northern California office. She often represents technology companies in disputes, as well as negotiating dispute clauses in enterprise critical agreements. Sarah and Jim, thank you for joining us.
Our pleasure.
Thanks, Julian.
Jim, why don't you start us off with a description of the common areas of dispute in technology agreements?
Thanks, Julian. A good place to start might be to describe exactly what we mean by technology disputes, which are really nothing more than disputes that arise from technology-based agreements. A good example of a technology-based agreement, for example, is a software license or software development agreements. Another example is a long-term technical service agreements, for example, information technology service agreements. Still other examples include collaborations to develop new technologies, joint ventures, for example, or agreements to implement a new IT system or a new IT process. These kinds of agreements tend to generate disputes that have certain characteristics in common. The first characteristic, and this is not at all surprising, is that these disputes tend to be factually complex and highly technical in nature. And as a result, establishing fault can sometimes be challenging, particularly when, as often happens, both parties played some role in the events leading to the dispute. Other characteristics of technology disputes is that they often involve forms of proprietary information, such as trade secrets, and they tend to be of high value, reflecting the high value of the underlying contract or the potential impact of the contract on a company's business. One final point I'd note, Julian, is that the parties to a technology agreement often have strong incentives to resolve disputes early so that they can preserve the overall commercial relationship.
Okay, but why then do disputes arise in the context of these agreements? What are some of the typical reasons?
I would say that the most common reasons are, one, a lack of clarity in the contract as to the respective obligations of the parties, or two, a factual disagreement as to whether one party has met its contractual obligations. As an example, the parties may have a disagreement as to whether certain contractual milestones have been met. Another common reason for disputes in this area is simply that the commercial interest of the parties may diverge, and one party no longer has the same motivation to continue the commercial relationship. And the final reason I would cite for disputes in technology areas is a lack of transparency, where one party does not have a complete window into what the other party is doing and believes that the other party may not have been completely open or candid about what it's doing. As an example, we might consider a party licensing software or IP who may come to believe that the counterparty has engaged in an unauthorized use of the IP. Another common area of dispute that arises from this lack of transparency is the ownership of developed technology. And of course, royalty disputes are very common in this area. One other reason I'd cite, Julian, for disputes in technology-based contracts is the deal structure is sometimes too optimistic, or at least not realistic. There may be, for example, an unrealistic implementation timetable driven by commercial pressures, or an unrealistic internal expectations as to the likely savings or profits from the deal. So there's a wide range of reasons why disputes in technology-based agreements can arise.
So, okay, so the question we're all wondering about then is what can parties do when negotiating technology agreements to minimize the risk of these types of disputes down the line? Sarah?
Sure, Julian. First, it's important to be realistic about the resources needed to manage technology contracts. You can't just sign the agreement and put it away in a drawer. You need to dedicate resources to ongoing monitoring and compliance. Second, you want to limit agreements to agree details. Agreeing later might seem tempting to move things along in the short term, but it leaves open opportunities to fight later. At the time of the initial deal, the parties are often getting along. They're optimistic about the relationship and they're working towards a common goal. But when a dispute arises down the line, the relationship commonly has devolved into a more negative situation. One example that we see is deferring the decision of whether there'll be 1 or 3 arbitrators in a dispute clause. That might seem appealing in the short term because the parties can wait and see what the amount in controversy is or the complexity of the dispute before making that call. But we recommend resolving those types of issues upfront or risk litigating them later. It's also helpful to include effective dispute resolution provisions, including considering an accelerated process for smaller or more technical issues, so you can keep things moving along through minor disputes. Not every dispute needs to blow up the deal or the relationship, and this is a great way to support a longer-term relationship and to achieve longer-term, larger goals. And finally, to ensure that there are realistic project milestones and clear consequences for failure to perform. When you have partial performance on both sides before a dispute arises, the legal and factual inquiry can get very mucky. Milestones and associated consequences are also a great way to set both sides' expectations up front.
Okay, so you touched on the dispute clauses a bit. Jim, as a preliminary matter, when negotiating these dispute clauses, when should clients be insisting on arbitration versus litigation? What should they be thinking about at the dispute clause drafting stage?
This is a great question, Julian, because there are advantages and disadvantages for both arbitration and litigation that depend on the specific facts of each technology agreement. And they're very important to weigh at the beginning when you're drafting or thinking about a dispute resolution clause. In fact, there are some, what I would say, general considerations that are important in all commercial agreements, but particularly important in technology transactions. The first question being whether the opposing party is based in another country. This simple question is important because if the opposing party is based in another country, then this will almost always argue for arbitration, international arbitration, as the method of dispute resolution, for the simple reason that you do not want disputes to be resolved in the home courts of the opposing party. If both parties are based in the US, the next really critical question is how important is the right of an appeal to the company? This is a critical question because in arbitration, there is no real meaningful appeal from the arbitrator's decision. It's a final decision. Whereas in a court, an adverse decision can be reviewed by an appellate court. And as a result, if the right of appeal is important, for example, if there's critical intellectual property that's at issue in the dispute, or that could be at issue in the dispute, the company may want to prefer litigation for the simple reason that it would have a right of appeal. There are other important considerations, one of which is what we sometimes refer to as a rational decision maker. This is an advantage for arbitration because with arbitration, you can require in the dispute resolution clause a decision maker who has background in the relevant technical area or even the relevant area of law. Whereas in litigation, you sometimes have decisions made by jurors who have absolutely no background in the technical area. Another important consideration is whether you contemplate a long-term service or other relationship with the counterparty. The reason this is important to think about is because if you do contemplate a long-term relationship, you'll want to consider building into the dispute resolution clause some disincentives to litigation or arbitration. For example, requirement that the parties mediate, or a provision that awards attorney's fees to the prevailing party. This will encourage the parties to resolve disputes rather than litigate them. It will also encourage an early resolution of disputes, and in that way preserve the long-term commercial relationship. A couple of other considerations to keep in mind, Julian. One is confidentiality. If confidentiality is important, for example, if there are trade secrets involved, then that will be an argument for arbitration, because arbitration is far better method of dispute resolution to preserve confidentiality than litigation. Cost containment is another important consideration. If cost containment is an important goal, then this also will be an argument for arbitration, because you can limit the scope of discovery, you can limit the scope of the hearing, you can limit the scope of attorney's fees. A final consideration that I would note is what we sometimes describe the risk of arbitrary results. And what we mean by this is, are there ways to minimize the risk that you will get a decision that is really unjustifiable in terms of the facts of the case or the legal principles? I mentioned earlier the right of appeal in litigation. The reality of an appeal sometimes imposes a discipline on the judges who do not want to be reversed on appeal, to follow the law and to follow the facts. Because there is not that same appellate right in arbitration, some parties fear the risk of an arbitrary result in arbitration. On the other hand, if the decision will be made by a jury as opposed to a judge, then that might be an argument for arbitration, because jurors are oftentimes more emotional and not as attuned to some of the technical issues. So as you can see, there's a wide range of considerations that need to be taken into account, and it's a very fact-specific question, but it's a very important question: litigation versus arbitration.
Okay, so this is a great roundup of measures that can be taken when negotiating the agreement to try to minimize the risk of disputes happening. What about, after the ship has sailed, though, and the dispute does arise? What advice, Sarah, do you have for clients in that circumstance? The dispute has arisen. What do you do?
Thanks, Julian. And as you say, even despite best efforts, disputes happen. As with any type of agreement, when a dispute or disagreement arises in the technology context, the place to start is investigating the facts, preserving evidence, and getting an understanding of the relevant legal merits. The next step then really is to define objectives. Winning cases is great, but winning might mean something different in different circumstances. Sometimes you can achieve commercial goals with something short of winning a litigation or an arbitration. And so once you've investigated your facts and understand the merits and have defined your objectives, then it's time to determine a strategy and use your dispute resolution mechanism at an early stage as a tool to achieve those commercial objectives. Generally, we advise clients against ignoring disputes or allowing them to fester. At worst, you risk waiver or course of conduct issues, but you also risk losing the opportunity to build a long-term relationship or to achieve a larger goal. And then lastly, if you agreed to complex government provisions, be sure that you have resources and time dedicated to adhering to those provisions. You don't want to give the other side claims and defenses based on your failure to comply with technical contract requirements. It's always easier to win when you've been diligent in doing what you're required to do under the contract.
Sarah, you mentioned governance provisions. What kind of provisions are you talking about there?
Sure. So the type of governance provisions that we're contemplating there are really any requirement in the contract that requires a party to do something at some point after signing. So frequently contracts include notice provisions or change of control provisions or other obligations in the contract that are triggered by something that occurs after signing the contract. You just want to be sure that you comply with those provisions over time so that you're not providing the other side with technical breach arguments.
All right. Any final thoughts for our listeners, Sarah? I mean, say I'm a lawyer about to negotiate a major technology agreement for my business. What's the one piece of advice you'd want me to take away from this episode?
That's a great question, Julian. And us litigators, we understand that the dispute clause might not be the most important negotiation priority in the moment, but keep in mind that it's the first clause we look at when we get the agreement after a dispute arises. That's our starting point for thinking through options. So it is worth some thoughtfulness on the front end.
Well, thank you, Sarah. And thank you, Jim. We appreciate your insights. Listeners, if you have any questions about today's podcast or anything else related to technology transactions and the law, please email us at techtransactions@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.